E Jean Carroll is not a victim. E Jean Carroll is a winner. E Jean Carroll beat Donald Trump in civil court, federal court, not once, but twice. Once for $5.5 million, once for $83.5 million. She's owed almost $100 million, and Donald Trump is still jerking her around and abusing her, even at this late date, in appeals. And he's lost. He didn't just lose small, he lost big. 8-2 at the Second Circuit. We break it all down for you, what that case was about. Spoiler alert, a jury found that Donald Trump sexually abused E Jean Carroll and defamed her, not once, but twice. This has no presidential overlay to it. This was all before he was president, the $5.5 million. And then the 83.5 is what happened to him after when he was president and defamed her as president of the United States. We cover it all on Legal AF on the Midas Touch Network. Take a listen.
Trump got due process in the E Jean Carroll sexual assault case where he was found liable. Trump got due process in the E Jean Carroll defamation case where he was found liable. Trump got due process in the business records case where he was found where he was criminally convicted on 34 felony counts by a unanimous jury. Donald Trump got due process in his civil fraud case brought by the New York Attorney General, where he was found liable for massive fraud for, guess what, Popok? Making up fake numbers. Kind of like what we see him doing now in the office, right? Like saying that this is worth 500 billion, or 500 million, 100 million, 2.6 billion. Just change the numbers and inflate and deflate valuations whenever it benefited him, just making up numbers all of the time. That's exactly how he's treating our economy, wrecking our economy. But going back to Trump's due process, why don't you talk about E Jean Carroll? I've got an update there.
Yeah. Great update. So E Jean Carroll was two cases, right? One had to do with whether a jury would find that she was sexually assaulted by Donald Trump in a dressing room at a department store near Trump Tower back in the 1990s, and whether she was defamed by him when he denied that happened and then attacked her mentally, emotionally, physically. I mean, talking about what she looked like and everything else, and just classic defamation. That was before he was president. And then the second case, dovetailing on that, both federal, both in front of 9-0 juries, presided over by the same judge, Judge Kaplan. The second trial, Carroll 2, we call it, was for the same set of facts, but now to be assumed by the second jury that the sexual assault happened, as that term is used under New York penal law, and that whether he defamed her again while he was president. The first case that went up so he lost both. First case he loses. Alina Hobb is the lead lawyer, along with Joe Tacopina. Donald Trump does not testify. Infamously goes to Scotland and decides to go into the bunker of one of his golf courses rather than testify, threatening to testify, but never does. And he loses. The jury finds sexual assault happened and that she was defamed and awards her $5.5 million. So we have a next trial. They appeal that. Okay. And that's the appeal I'm going to talk about next. They post the $5.5 million cash. Second trial happens about a month or two later. All before the election, by the way. Second trial, Tacopina's replaced. Haba's out. They bring in new lawyers. And Donald Trump testifies. And blames Joe Tacopina for not letting him testify the first time. And how did that go? Not well. Jury awards $83.5 million now to E Jean Carroll. That had to be bonded by Donald Trump because he couldn't scratch up enough cash at the time or didn't want to. It's now running with interest at about $100 million. That appeal sort of is based on this appeal. The first appeal by E Jean Carroll on that case, because it dealt with presidential comments or comments made while he was president. Better way to put it. Alina Hobb gets trotted out to argue at the Second Circuit Court of Appeal, and they say, interesting, but you didn't raise it in time, and you waived any presidential immunity argument or executive privilege argument. And that was, they could have taken it and tried to take it to the Supreme Court, but that's where it lies. It sits there at the Second Circuit, and she lost. Now they also appealed the $5.5 million, and they lost 2-1 at the Second Circuit way back when in December 30th of 2024, after the election, but before he was inaugurated. And that's when, Stephen Chung takes to social media, White House communications director, and says, Donald Trump got elected to reunite the country. Is that what we're watching? I'm sorry. Thank you. Is that what we're watching over the last 170 days? The reunification of America, and peace and love. And yet this, and he attacks the court and he attacks the judgment, attacks the judge all over again. So Trump asked for what we refer to in the business as an en banc reevaluation of the appeal by the full entirety of whoever wants to participate at the Second Circuit, which is about 10. This time it's about 10 people because 4 or 5 judges have said, I got a conflict, I'm not around, I'm not here. So 10 judges looked at it. In order to get an en banc review to overturn, to overturn what the 3-judge panel had ruled, you have to get a majority to be interested in that. So you got to get 6 out of the 10 to say, yeah, let's see it. Does he get 6 out of 10? No, he gets 2 out of 10 because the other 8 said, yeah, not interesting. In order for you to win, there had to have been a manifest error, what we call reversible error by Judge Kaplan about evidence that was admitted. The main attack by Trump was Judge Kaplan shouldn't have allowed in 2 other women who testified about being sexually assaulted by Donald Trump at other times. And they shouldn't have let in the Access Hollywood tape, where Donald Trump is infamously caught on tape, which he's never denied because he can't, about sexually assaulting women and getting away with it because he's a celebrity. And they shouldn't have allowed in some other witnesses that were contemporaneous, what we call outcry witnesses, who testified about what E Jean Carroll told them at or about the time of the sexual abuse, and a lot of other things that happened. And let me just be straight with our public, with our audience. Due process does not entitle you to a perfect trial. I've done 35 trials. I've never had a perfect trial. Nor does it entitle you to an error-free trial. It just entitles you to a reversible error-free trial, that it's not so manifestly erroneous that it didn't undermine your liberty, your due process rights. And so they said, look, the court originally said, look, Judge Kaplan made his decisions and has broad discretion, wide berth to make decisions about evidence. And given that, and the things that you've pointed out, we don't see a retrial here happening. And that was the ruling. It went up for the vote. And one of the 3 judges that originally ruled jumped out with another statement in support and concurrence of the decision not to grant another appeal, and said, there's nothing that you've raised that would require relitigating this case. No error that is so erroneous, so beyond the pale of law, that we would reverse the ruling and give you a new trial. So en banc denied. They don't even get to en banc at all. Now, his last stop, but I think it's a loser, Ben, is the United States Supreme Court, because you and I talk a lot about how this panel, this 9 justices of the Supreme Court, will rule when it comes to Donald Trump on lack of due process for immigrants or presidential power or DOJ or this or that. But when it comes to a case about Donald Trump before he was president, about a sex abuse judgment of a jury 9-0 and an affirmation by an appellate court, I just don't see them being interested enough to even take an application, it won't be emergency, to even take a writ of certiorari and take it up on appeal. What do you think?
I agree. I don't think the Supreme Court will take it up. I mean, perhaps Donald Trump tries to be creative, is probably not the right word, trying to use some sort of presidential powers hook to not have to pay right now. I don't know what that even looks like, but this is not a case involving presidential powers. This is not a case involving presidential immunity. This is not a case in the course and scope of anything that he's doing in terms of his Article 2 powers. So, I mean, the appeal to this full en banc panel of the Second Circuit was related to really just evidentiary issues about propensity evidence. Their main issue on appeal basically is the fact that Donald Trump would continue to brag about sexually assaulting women throughout his life. should that have come into evidence? That's basically the issue. And those two dissenting judges said that even though Donald Trump his whole life had said, or frequently made comments about sexually assaulting women and grabbing women's vaginas without their consent and doing that shouldn't have come into the trial about E Jean Carroll. That's where the two said that was prejudicial to Donald Trump. So I don't think the Supreme Court weighs in on this, Popok, for that reason as well. But I think it's important for people to know what Trump was. The central part of Trump's appeal is you shouldn't have held all of the stuff that I did in the past against me on a case where I was found liable for sexual assault. Just because he said it all the time in the past, should that have come in or not come in?
Even though there's a rule of evidence related to sex abuse crimes that allows that very evidence in, it's an exception to the general rule that you and I, have done when we've been defense lawyers, which is no, you don't get to bring in unless it's modus operandi or other things, bad acts in the past need to stay outside the courtroom so as not to influence the jury, except in matters like sexual abuse charges. Welcome back. We sit at the intersection of law and politics so that you don't have to. We try not to blow smoke or sunshine. We tell it like it is as lawyers, as practitioners. I've been doing this 35 years. I'm a nationally acclaimed trial lawyer. I know what I'm talking about. So does Ben Meiselas, and so does Karen Friedman-Agnifilo. We get together Wednesdays and Saturdays with our audience to walk through these issues. We do it in an informative way, hopefully an entertaining way. We try to demystify the law for you, and we could use your help now. If you want to watch us, of course, maybe you just wandered in, algorithm sent you here. You can watch us on Wednesdays and Saturday nights at 8 p.m. Eastern time for a video version of the podcast. If you want to listen to us, audio versions you can get anywhere you get your audio podcast from. Just plug in Legal AF. We could use the help on both. We need more audio downloads and we can use more views. Put that together and we got a winning show in the top 50 every week in news on podcast platforms and the #1 YouTube podcast out there with your help. So you can do it through Legal AF support at the podcast level. Come over to Legal AF, the YouTube channel, Legal AF MTN, for hourly reports at the intersection of law and politics like no other YouTube channel out there. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.